All right. So, what I want to talk about is we're going to go over some things for the FDCPA and we're going to make something clear. I really don't talk too much on consumer law, as most people know. I'm more on, you know, uh, I'm more on when it comes to contract law, but there are nuggets of gold, consumer law, if you know what you're looking for. And since we're going to go over this should put a little perspective that a lot of businesses that you think are not under the FDCPA, like people say, well, the FDCPA doesn't apply to original creditors. Well, think again. The FDCPA does apply to original creditors, especially if they collect debt in a secondary name, like Chase or Chase Bank will collect debt in JP Morgan. I'm sorry, in card member services. Wells Fargo will collect debt in the name of Wells Fargo card member services or whatever. You know what I'm saying? So they collect debt in secondary names. And you will notice this by the statement. So sometimes you have to look at the statement and then say, hey, you guys are not the original creditor. You guys are subject to the FDCPA also. So as the song by The Who asks, who are you? When it comes to the Fair Debt Collection Practices Act, many companies think they know who they are. If they are third-party debt collectors, they're covered by the FDCPA. Pretty much everybody is a third-party debt collector. And the way that you can figure this out is you can ask for certain information on your account, and it'll prove that they're third-party debt collectors. Okay, if they're creditors collecting their own debts, see, their own debts, meaning obligations owed by them, not obligations owed by another party, their own debts. Okay, they aren't. But as I mentioned, recently in a presentation at an industry event, it is not that simple. Some creditors and others may not realize that certain courses of conduct can put them squarely in the jurisdiction of the FDCPA. Okay, when you start looking at your statements and stuff, and you start seeing banks are collecting in different names and they're starting to forward you to attorneys, the attorney, the moment that they transfer that to the attorney becomes a third party debt collector. Okay, I want y'all to understand that because the attorney is not suing on behalf of the bank because he is not a party to the contract. Okay. The starting point, of course, is the language of the statute, section 803(6) of the FDCPA defines a debt collector as any person who uses any instrumentality of interstate commerce or the mails in any business, the principal purpose of which is the collection of any debts, or who regularly collects or attempts to collect directly or indirectly debts owed or due or asserted to be owed or due another. Okay, so now we understand that technically the FDCPA applies to all of these people because they're collecting debts and then they're putting them into trust or other vehicles or SPVs, which are special purpose vehicles. Okay, so that means they're all third party debt collectors. See what I'm saying? So you can prove this by asking certain questions. I don't really use the FDCPA, but I do sometimes use elements of it to get stuff off people's credit or whatever, right? Creditors who collect their own debts may see that definition and stop reading. Big mistake, because section 803(6) goes on to say the term includes any creditor who, in the process of collecting his own debt, uses, see, he said his own debts. So they're already telling you that you don't owe the debt. See how the semantics and how the double speak saying his own debts, not saying debts that are owed to him. They're saying his own debts. That's why I was trying to teach you guys that that when you're signing these agreements, you're signing a servicing agreement, and the servicing agreement acts as a power of attorney for them to act in the shoes of the principal of the account. Okay, uses any name other than his own, which would indicate that a third party is collecting or attempting to collect such debts. So I got a fire letter I'm thinking about releasing that's going to show you how to pick these people off and put them right in the FDCPA, even if they try to hop out the water. In other words, if a creditor collects its own debts but uses a different name, that suggests it's a third party debt collector. Presto, the company is now a debt collector subject to the FDCPA. What? Yes. So if they send your stuff to Wells Fargo Collections, if they send it to Chase Collection Group, guess what? They're now under the FDCPA. Oh, you can't make this up. The FTC has gone to court to challenge the FDCPA violations by companies that used other names to collect their own debts. For example, Lone Point LLC and Utah-based payday lending outfit did business as eCash or Gate Cash, something like that. But when it came time to collect those debts, the defendants used the company name Lone Point. Therefore, in addition to the allegations under Section 5, the complaint charged them with the FDCPA violations, including illegally garnishing consumers' paychecks and revealing the existence of debts to people other than the debtor. So, see what I'm saying? So, like, say if you have a car and you go and finance it through Audi, and then VW Credit sues you, okay? VW Credit is a third party debt collector. They're a secondary debt collector. They're violating the law. And if an attorney does that, they're committed fraud. The FTC urged and the trial court agreed that the defendant's conduct made them debt collectors under that second sentence of Section 803(6). There's another provision that some companies mistakenly read as putting them outside of the FDCPA. Section 803(6) FIII exempts the FDCPA any person collecting or attempting to collect any debt owed or due, to the extent such activity concerns a debt which was not in default at the time it was obtained by such person. I add emphasis. But what about a debt that is in default? According to the FTC and several federal appellate courts, if the debt is in default when the company obtained it, the company's activities to collect that debt are covered by the FDCPA. So, like, say if you were in default on a mortgage and the mortgage company transfers it, that means that the company that obtains it is definitely regulated under the FDCPA. Okay, that's what the FDCPA alleged in cases like Fairbanks Capital, EMC Mortgage, Compute Credit, Consumer Portfolio Services, CPS, and Green Tree Servicing. For example, Auto Loan Servicer CPS buys and services financing contracts from car dealers across the country, thus putting them under what? The FDCPA. See, I try to tell y'all, like, these car loans, right? They don't have a right to collect these car loans, okay? But when collecting on accounts that were delinquent or charged off at the time, CPS purchased them or acquired servicing rights. Servicer CPS became debt collectors, CPS with regard to those accounts. The FTC CFPB settlements with Green Tree, now Dycheck, also illustrates that principle. Green Tree contracted to service mortgages that other lenders extended to consumers. As such, Green Tree created and sent monthly statements, processed payments, and property taxes, etc. But many of the accounts Green Tree serviced were already in default when Green Tree acquired them. Thus, for those accounts, Green Tree donned the additional hat of debt collectors subject to FDCPA. Okay? Now, what people have to understand is, right, when you get a loan and the loan has the amount due and owing, right, it's already in default, right? Because what happens is when you go to a closing table, you're really going to an opening of escrow. So how can a loan be current if it's set up to where you still have an outstanding amount. You know what I'm saying? It's outstanding within it's current within the contract. But whenever they take this note and transfer it, right, it's a non-recourse loan. So they don't have the ability to collect on it. So they're really under the FDCPA. They're federal, they're debt collectors. You see what I'm saying? Coverage under the FDCPA changes the compliance calculus which is why creditors need to know if they're subject to that law. The FDCPA imposes additional obligations, and non-compliance can be costly. For example, under Section 809, within 5 days of after the initial communication with a consumer, the debt collector must send a written validation notice, including, among other things, the amount of the debt, the creditor's name, and the details about the procedure for disputing the debt. In addition, Section 807(11) requires certain specific disclosures that the debt collector is attempting to collect a debt, and that information obtained will be used for that purpose, often called in industry parlance the mini Miranda. Yep, we used to use that when I used to be on the phone. But even the FDCPA doesn't apply. Even if the FDCPA doesn't apply, your collection activities are still covered by Section 5 of the FDCPA, of the FTC's Act, General Prohibition Against Deceptive or Unfair Practices, as cases like AMG, Payday Financial, and Cash Today demonstrate practices that are false or misleading under Section 807. See, they already know this stuff of the 807 of the FDCPA. Bogus claims of government affiliation or false threats of legal action, to name just a few, violate Section 5(2). The same can be said for the host of unfair practices listed in Section 808. In addition, the FTC has taken action under Section 5 when the first party creditor engaged in other practices expressly prohibited by the FDCPA. For example, revealing the existence of a debt to anyone other than the debtor. What? So now y'all understand my silver bullet video. Y'all think I'll be playing like when y'all get a traffic ticket, you don't know that that's identity theft. Y'all think I'll be playing when y'all get a mortgage and the mortgage is registered on public records. That's identity theft. Because the Constitution says what? You have a right to be safe and secure in your papers. That means you have a right to not have your private information on a public platform. And with that being said, I'm out.